The ADA website lawsuit game usually results in a settlement, and this is because settlements provide assurance and are efficient. Assurance in the sense that we resolve the matter versus continuing into the unknown and risking an adverse judgment, and then efficient in that we very likely save both time and money in not continuing to defend the case. But what if you're considering not settling? I think there is a path to success, but it's going to depend on various factors, some of which I have on the whiteboard. So let's first start off with when I say not settling, we are not trying to see this to a verdict. We are trying to get your case dismissed as soon as possible. So with that in mind, the first factor is the plaintiff's law firm. You have to remember that plaintiffs' law firms are different in their approach. Some plaintiffs' law firms are more willing to abandon their case than others. Some plaintiffs' law firms are more litigious, and there are many more differences that we can keep in mind that would factor into our decision. Also, courts are different. Some courts are more receptive to dismissing these cases. Some courts are very hostile to plaintiffs' law firms. Other courts are more receptive to these arguments. So you have to keep in mind what court you're in. Also, your attorney is everything. You need an attorney with the right frame of mind, with the right mindset, and you need an attorney who is not only experienced in ADA website litigation, but you also want an attorney who is successful, who has been successful in getting at least one case dismissed. So part of this, as I mentioned in the mindset, is the willingness to initially defend this case. And then also you want to see that they have had a case successfully dismissed. But you need an attorney with a balanced approach because there is no singular right way to do this because it's going to depend on your circumstances. So your attorney is everything. Finding the right attorney is everything. Also, in terms of getting the case dismissed, one route is based on mootness. So with mootness, basically there is nothing in controversy. So in this instance, we would have the plaintiff's law firm claiming that your website is inaccessible, and then you would moot that claim by stating, no, our website is accessible, and then demonstrate evidence of that accessibility. And then so I have an arrow pointing from the mootness bullet point to the ADA compliance program. So through accessible.org, I offer the ADA compliance program, and I really designed this to be completely thorough. And one of the considerations I had in mind was getting a case dismissed. So the ADA compliance program includes an audit, it includes remediation, it includes a user testing session that is recorded, and you will have access to that recording. You will have documentation of that user testing. You will have the ability to have provider certification and then also a conformance statement. And those two last documents are really serve the same purpose, but they are different in the details that they provide. But the point here is that if you were to go through and choose the ADA compliance program, then it would provide everything that you would need to potentially have a claim or have a motion to dismiss for based on mootness. So with that in mind, you can also get a case dismissed based on the plaintiff lacking standing and the plaintiff not actually suffering an injury. Of course, that is going to be fact specific, but that is also potentially there for you. And then one other note I have here is that the plaintiff's lawyer's attorney's fees may not be reasonable in the settlement. So what happens with the settlements is they are typically inflated. And when we actually break down the work that the plaintiff's law firm has done, it may not be as much as they are asking for really implicitly in the settlement. So keep that in mind. And then a few other points I have on the whiteboard. One is it is possible, although it is remote, it is possible that you could get a recovery of fees if you can prove that the complaint was frivolous. Also, there is the ability to leverage time. This is part of the strategic component of defending these cases. So there's definitely a strategic side to this, and just keep in mind that the use of time can work in your favor. Also, I would pay attention to the effort level of the plaintiff's law firm in the complaint filed in court and or potentially the demand letter. But really, I'm thinking about the complaint filed in court. So the level of specificity they have, the level of detail, that's also going to play a part in my decision. So as I've said, this isn't a one size fits all. It really is dependent upon your circumstances. Um, if you need help, I offer consultation through accessible.org. Also, with adacompliance.net, my flagship course is the ADA compliance course, and this course is designed to help you prevent these very type of lawsuits, because this course tells you how to find and fix the most commonly claimed issues, accessibility issues in litigation. So the course is very thorough. It is available at adacompliance.net. Of course, I offer services at accessible.org. The primary one that I recommend to everyone is the ADA compliance program. And then I also offer consultation through accessible.org. So all of that is available to you. I will include links to all of these resources in the description. But the point of this video is, if you are thinking about not settling your case, there may be a path to success, but it's just going to depend on various factors.